This meeting is now being recorded.
Hi, I'm Kimberly Simmons, the Executive Director of the Public Defense Commission in Idaho. Today I'm going to talk to you about two chapters of rules that we are proposing or are in negotiation. The first chapter is IDAPA 610108. This talks about our rule definitions, so any words and terms that we use in our rules will be defined here. This chapter also incorporates documents that we've incorporated by reference, and they will be referred to throughout all of our chapters as well. The second chapter I'll be talking about today is IDAPA 610106. That one is related to oversight, implementation, modification, and enforcement of standards. This year, what we're proposing is language that goes to oversight and enforcement. At some point in the future, we will address implementation and modification. A roadmap for today's presentation. I'll talk a little bit about the Public Defense Commission, our authority and mandates and where they come from. If you've seen any of my presentations before, some of this will be redundant. But I do think it's important to sort of remind you where we get our authority and the things that we are supposed to be doing. And then I'll briefly talk about who we are. And I will talk about the Public Defense Commission administrative rules, what rules are currently in effect, where can you find them, and what are we proposing right now, what's the negotiation and all that. And I'll go through a little primer on administrative rules as well. Just to give you a little background on what rules are and what they mean. And I will talk about the IDAPA chapters, 610108 and then 610106. So first, where does the Public Defense Commission come from? We are given our authority and powers by the Idaho Public Defense Act, Idaho Code Section 19848 through 19866. Specifically, in 19850, it talks about all the things that the Public Defense Commission can and must do. The Public Defense Act, at least the title of the act, is fairly new. However, many of these statutes have been in effect since 1967. But of course, many of you know that the Public Defense Commission came into being in 2014, and the statute was sort of beefed up, if you will, in 2016. And this 19850 was enacted last year and went into effect July 1st. The Public Defense Commission has been told by the legislature that we are to create rules. So this portion of the statute says shall, and in several different areas. That first area is related to training and continuing legal education requirements for defending attorneys. Also, uniform data reporting requirements and model forms is a rule that we are to create. Rules related to model contracts, core requirements for those contracts. Allowing counties to apply for indigent defense grants to help them come into compliance with indigent defense standards that we create. So basically anything created underneath this statute, that's what the grants are for. Rules related to the Administrative Procedure Act, giving parties a mechanism to appeal any decision that the Public Defense Commission may make through administrative procedures. Rules related to the oversight, implementation, enforcement, and modification of standards. And then finally, rules related to standards for defending attorneys. These are to be based upon Idaho's principles of a public defense delivery system. There are 10 of those, and they are listed in this statute. In the same statute, sections 1B through E, we are also to make recommendations to the legislature. This is still the shall portion of the statute. And by January 20th of each year, the legislature wants us to make recommendations regarding the public defense delivery system in Idaho, but they also specifically spell out these two areas, how to enforce the standards, but also any funding issues. I will note that the funding issues for this next year, so not this session, but fiscal year 2019, the cap on indigent defense grants does expire, if no action is taken, that just means there's no cap. It doesn't mean that the funding is gone or that indigent defense grants won't be any longer. It actually means that there's no cap. I do anticipate, however, that there will be some recommendations either from the Commission or someone in the legislature about the cap and establishing or amending the statute to create a new cap or keep the same cap. That remains to be seen. The next part of the statute gives the Public Defense Commission the authority and duty to review indigent defense providers and defending attorneys, and also to establish temporary procedures and model forms for indigent defense grants. This section of the statute was more relevant last year when we went to our first round of indigent defense grants. We did not have a rule in place. We did establish a temporary rule this year for those procedures. And the biggest reason that we established a temporary rule in regard to the indigent defense grant is because the statute specifically says if we move forward on temporary procedures, so without a rule, then parties would have no means to appeal a decision that we made. So for instance, if we had denied a grant application from a county, there would have been no way for a county to appeal that decision. So we created a temporary rule this year, which I'll talk about briefly in a moment. The next section of the statute gives the Public Defense Commission some other authorities, but this is listed under may. We may do these things. So the Commission may hire an executive director and other personnel, which obviously it has done. We may provide training and continuing legal education for attorneys, which we have done. We may establish procedures for providing extraordinary litigation costs to the counties. And we may hire private counsel to represent the Commission in hearings per Administrative Procedure Act and rules that are created pursuant to this section. Who are we? The Commission is made up of 7 members. They're on the left side of your screen. We have a member from the Juvenile Justice Commission, State Appellate Public Defender, Idaho Association of Counties, and a representative defending attorney. Those 4 positions are appointed by the governor. We have a representative from the Idaho Supreme Court, and then 2 representatives from the legislature, 1 from each house, and you'll see who those are currently. Our commission members are volunteers, though their travel and per diems are paid for if they travel to a meeting or travel on behalf of the Public Defense Commission. The staff are paid staff, and we are mainly administrative. We have myself, the executive director, Ms. Kelly Jennings, our deputy director, our full-time administrative assistant and office manager, Nicole Devani. And then we have 3 regional coordinators who started with us in May throughout the state. And I want to make a special shout out here to Mr. Aaron Freudenthal because he created the background of this PowerPoint that you see, very nice and professional looking. But many of you have met our regional coordinators throughout the state. They're there to help counties and defending attorneys in regards to the public defense system. Administrative rules. So what are administrative rules? Well, in the hierarchy of state documents, you would start out with the Constitution. So Idaho Constitution is the prevailing authority. And then you have the legislative statutes, which would include the code that gives the Public Defense Commission their authority and duties. The next step would be state agency rules, and this is where administrative rules fall. And they have the force and effect of law. Then there are policies. This would be like a mission statement from an agency, internal management tools for the day-to-day operation of the agency. Policies do not have the force and effect of law. There are procedures. Just a step-by-step implementation of policy. They do not have the force and effect of law. And then you have guidelines and other written interpretations. You can have written interpretations of your administrative rules, for instance. These are description of the procedures. And again, these do not have force and effect of law. The rules and how they're created, how you're supposed to write them, They have to go through an approval process all through the Office of Administrative Rules Coordinator. And I put that website there for you in case you're ever interested in looking up the rulemaking manual. They also have all of the rules on their website for all of the agencies. That's where you will find legislative bulletins that publish proposed rules, pending rules, those kinds of things. It's quite a resource. And then something else to know about administrative rules is the Administrative Procedure Act. And this will outline definitions used in rulemaking. It defines how or provides the framework for agency rule creation, talks about contested cases. So, when an aggrieved party appeals a decision by a state agency, the Procedure Act will go through the processes for appealing those decisions. There's judicial review, and then there's also a section talking about the legislature's review of rules. So the Public Defense Commission does currently have rules in place. They were effective May 1 of last year. And our statute says that any rules that we create that are effective on May 1 of any given year have to be complied with by March 31st. And in the next slide, I believe I will talk to you about which rules are current so that you'll understand which ones have to be complied with by March 31st of 2018. And talk a little bit about the process to create rules now. And the process that the Public Defense Commission uses and most state agencies use is called negotiated rulemaking. This is an informal part of the rulemaking process in which all interested and affected parties and the agency seek to reach a consensus on the content of a rule. It's generally informal, flexible. In March of this year, the Public Defense Commission went out and held meetings across the state where we talked about the rules that we were going to propose this year, attempted to negotiate these, and I thought that they were successful, which we're open to comment and suggestion on those to make them even more effective and useful for rule creation. But the Public Defense Commission has committed to creating our rules through negotiation so that we can create rules that will meet our objectives, but also be something that our constituents could live with, if you will, work with. To make rules that are reasonable, but also meet our Constitution and statutory mandates. The next step in rulemaking is to propose a rule. So this is something that happens after you go through the negotiated rulemaking process. We do have a few rules in the proposed stage, which I'll talk about in a moment. This is a formal written proposal by the agency to adopt a new rule. Agencies are required to hold public hearings to take comments if folks choose to participate. We do have public hearings for our proposed rules that will start next week, as I had mentioned previously. The notice of proposed rules is printed in the legislative bulletin, and there are deadlines in there. I would encourage you to take a look at those. But a proposed rule does not have any force and effect of law, at least not yet. A temporary rule is a rule that can be made immediately effective and enforceable upon its adoption by an agency. The Public Defense Commission has done this only 2 times. We created a temporary rule regarding training and continuing legal education of defending attorneys. This was not the rule that talked about how much training a defending attorney had to acquire each year. This is the rule that was put in place for the administration of training funds. We felt it was appropriate to make that immediately effective because we were appropriated money from the legislature to provide training. We wanted to be able to do that. So that's what that temporary rule was about. The other temporary rule we created was the one regarding indigent defense grants. And that just addresses the procedures for counties to apply for grants and then the procedures by which the Public Defense Commission would review the applications and approve or deny a grant. We don't, not that I am aware of, have any plans to create any additional temporary rules, at least not at this time. A temporary rule will expire at the end of a legislative session unless there's a request to extend it. And then if there's no request to extend it, it expires and it goes away. It's no longer effective. But if the legislature approves it, so if it becomes a pending rule at some point and the legislature approves it, it does become a final rule. Pending rule defines a pending rule is a rule that has been adopted by an agency under regular rulemaking procedures, but it remains subject to legislative review. Therefore, it's pending for legislative review for final approval. This is essentially the agency's final rule, but it is not effective and enforceable until the legislature approves it. We have not submitted any of our rules as pending yet, but we do anticipate submitting some of our proposed rules as pending in November, and they will be published in the January legislative bulletin. Now, where can you find all of this information on our rules? What's current? What's under negotiation? What's proposed? What's temporary? The first place that I would go is our website. And I'm pulling that up here. Let's see if I can get this to share. Just one moment. I apologize, I'm sharing the wrong screen. Okay. Well, if you go to our website, here we go. On our front page, we have the PDC News Flash. This just talks about things that are currently going on, and since we are sort of in the thick of rulemaking, you'll see a lot of stuff here on your screen regarding the rules. And though we're not in rulemaking season, basically, you can go to the left side of your screen here to Rules and Standards, and if you click on that, then you'll see Rules. That's where our current rules will be. And you see Proposed and Pending, Negotiated Rulemaking, and then Resources. So if you click on Rules, this will take you to where the page that shows what is currently in effect. And right now there are 3. And when you go to Proposed and Pending Rules, you'll see the proposed rules. So these are the ones that will be addressed at public hearings. And you'll see our public hearing schedule. And then, as I had mentioned, we don't currently have any pending rules. And I'll try to keep this up to date. You'll see here on the bottom, there are no pending rules, and that was as of September 6th. That is still true today. Another place to see our rules would be on the rules website. If you click on that, that will take you to the Office of the Administrative Rules Coordinator. And I have already clicked all the way through to the State Public Defense Commission, and you can see here that we have 3 rules that are current. To find rules that are pending, you would have to go and search through the bulletins, which is why it's probably easier to go through to our website to find anything that's pending, proposed, and or temporary. Okay. Yeah. This is a table of what's current, what's proposed, and what's in negotiation. So, and the chapters that you'll see on the left side, so 610101, sort of matches with statute 19850 1A, then little I, which is 1. And those follow along. So there's 7 different areas in which we were mandated to create rules, so there's 7 different chapters. And then you'll see the 8th chapter, which we'll go through today, which includes our rule definitions and then the documents incorporated by reference. And the reason that we did that was because we were noticing that definitions were being used in our 1 through 7 chapters, And every time we change a definition, if we change it, we would have to change each chapter. So instead of doing that, we're putting all our definitions and documents into one chapter and then simply referencing that in our other chapters. It'll go through the same exact rule negotiation and rulemaking process as the rest of our rules. So as you'll see, we have 610101, which was effective May 1st. Again, that regards the training funds use. Then we have 610104, which was a temporary rule that was effective earlier this year. We have requested an extension of that temporary rule to get us through next year's grant application process. 610106 has been submitted as a proposed rule. You'll see that in tomorrow's legislative bulletin. 610108, you'll also see, 610107, you'll also see a proposed rule in tomorrow's legislative bulletin. But 610107 is also currently in effect. It was in effect as of May 1 of this year, and that I will talk about in depth in tomorrow's webinar. Then 610108 is currently in negotiation. I will go through that today. We do have a version of a proposed rule that I'll be submitting to the Rules Coordinator Office on Friday, and it will be published in the November 1st Legislative Bulletin. I'm going to take a moment here to tell you a little bit about this global meeting. If you look at the top of your screen, you will see Files as an icon. I'm getting ready to talk about our rules now. And if you click on the files, there should be 3 documents in there that you can download or you can open on your screen. So as I go through these, you can take a look at these rules as I talk about them. I would recommend you do that. I'm not going to pull them up on my screen. I'm just going to stick with the PowerPoint here. So the first one I'm going to talk about is 610108. Again, this is the one that incorporates all our chapter rule definitions and the documents incorporated by reference. Our authority to create this rule is in Idaho Code Section 19850, subsection 1. It's also 19862A. 19862A talks about compliance and our indigent defense grants and the authority that the Public Defense Commission has to enforce compliance as well as distribute grants to help that compliance. The rule consolidates the definitions and documents. Documents that are incorporated by reference in our proposed rule. I'm going to call it a proposed rule, but it's not going to be proposed until I submit it on Friday. But in the proposed rule, it incorporates the Idaho's principles of an indigent defense delivery system. This document is already incorporated by reference in the current 610107. That just has the 10 principles that Idaho has adopted that are loosely based on the ADA guidelines. This will also incorporate the standards for defending attorneys. Again, this document, there is a current version that is in effect, and that is incorporated into 610107 as well. We will also have an application for capital counsel roster that will be incorporated by reference into this chapter. This application is currently in the works. There is no draft of it yet, not to distribute yet because it's really, really in rough form, but we will hopefully have one available by the time that we submit the rules that's pending at the end of November. And then this chapter also has rule definitions. Now, if you've opened that document on your screen, you'll notice that there are a host of definitions in this rule. There are a lot. And so I'm not going to go through all of them today. I would encourage you to read most of them. Some of them are already part of rules that are in effect, and some of them are new. I'm going to try to go through the ones that I thought you would like for me to go through for today. The first definition I'll talk about is the annual report. When we talk about annual report, this is the report that defending attorneys must submit to their Board of County Commissioners, to their administrative district judge, and to the Public Defense Commission pursuant to Section 19864. The Public Defense Commission distributed an annual reporting form last year, but we did not require all defending attorneys to submit it to us that year. We didn't enforce that. We did receive a lot, and we are very grateful for that. It provides us some really great data to help assess the system and how it's working. This year, those annual reports for the statute are due in November, and we will be enforcing the submission of those forms. The annual reporting form is available on our website under the link entitled Forms. Capital Counsel rosters is a new definition. This will be a roster of defending attorneys who may be appointed to represent an indigent defendant in a case in which the death penalty may be imposed. I will speak to the Capital Counsel roster in more depth in tomorrow's webinar when we talk about the proposed standards for defending attorneys. But I did want to point out that there's a new definition and a new thing that the Public Defense Commission will be doing. The Supreme Court had contacted us a few months ago and suggested that we take over the roster. They feel uncomfortable reviewing cases in which they've approved somebody to be on the roster, and so they do think it's better that we handle that and create those qualifications. The definition of a case. This is not new. We do have a definition of a case that is in effect. The one in this proposed chapter is the exact same. We haven't changed it. There has been comment regarding that it doesn't match the Idaho Supreme Court's definition. I can tell you that the Supreme Court is looking at altering their definition. Also, their definition is more tailored to assessing caseloads of judges. Our definition of a case is supposed to be more reflective of caseloads of defending attorneys. And so there's slightly different purposes. But we do work in collaboration with the Idaho Supreme Court, and we're going to continue to do so to see if there is a way that we can come up with a case definition that can at least match each other, and so that people, that counties and attorneys aren't counting their cases in a bunch of different ways for different agencies and different entities. Caseload is a number of cases that a defending attorney has in a fiscal year. A compliance proposal, this is a new definition. This is something taken out of our Indigent Defense Grant Rule, which is 610104. This is a plan that is addressed in Idaho Code Section 19-862A, subsection 2. This is statutory. There's nothing in this definition that doesn't follow the statute, so it's basically a reiteration of something that's already law. But we put it into the rule to make it, easy access and easy reference. But basically, this is a plan that addresses how indigent defense standards are going to be met by a county and how much money, it should include a cost analysis of how much money the county requires to be able to come into compliance with standards, so that the Public Defense Commission can assess how much grant money a county would need. A corrective action plan. This is something new. This is, I'll talk a little bit about this when we talk about 610106 here in a moment. This is sort of an informal plan, if you will, developed by a county or a defending attorney with the assistance of a regional coordinator or someone from the Public Defense Commission staff. And it would address any deficiencies in the system. So anything that's not meeting up to current standards, the corrective action plan would be a way to plan how the county or the defending attorney would correct the deficiency. Compliance verification, excuse me. This is also a new definition. We noticed this year that if a county does not apply for an indigent defense grant, then we miss out on a lot of data. And it's data that the commission needs. And so if a county chooses not to apply for an indigent defense grant in a year, then they'll just have to fill out a compliance verification form to assure that the county is in compliance with standards and that they don't need any additional monies in which to come into compliance with standards. I imagine that we have not created a form for this yet, but I imagine it'll look something like the indigent defense grant application. Established standards and indigent defense standards, these are both defined in this chapter. and they're basically the same thing. They're any standard or rule that has been created by the Public Defense Commission, and it's defined simply because in the rules we talk about meeting established standards or meeting indigent defense standards, and we wanted to make sure that that definition was clear. It's also defined in Idaho Code Section 19-851, and so we basically took the statutory definition and placed it into the rule. Finding of compliance with recommendation. This would be a new definition. This will be in reference, used mostly in 610106, which I'll talk about in a moment. This is just basically a note by Public Defense Commission staff to a county that, hey, you're in compliance, but maybe there's something that could be improved. Our grant money that the Public Defense Commission gives to counties, there's two purposes for it. The first purpose is to come into compliance with standards. What if a county or an attorney is in compliance? Well, you could still get some money to improve your system, and so this might be a way to help a county or a defending attorney know how they can improve their system, and then they could ask for, additional grant money to improve the system by following some of these recommendations. This is not a determination of you're in compliance, but it's not enough. That's not it at all. It's basically an informal note just to let a county know or a defending attorney know that, hey, there could be some improvements made here. You wouldn't be obliged to follow the recommendations. The other purpose behind this definition would be, since the Public Defense Commission is still in the process of creating their rules, we may know of a rule that's forthcoming. For instance, the workload standard. We know that that is forthcoming. We don't know what it's going to be yet, but maybe in a few months we'll have a better idea. And so a finding of compliance with recommendation might say, hey, you're compliant with all of our current standards, but it seems that your workloads might be high for your attorneys, and we might recommend that a county, hire additional staff or something, because we know that a workload standard is coming, and it would be something that you would need to comply with in the future. It's meant to be a helpful thing, not something that's supposed to be a burden. Finding of non-compliance. This refers to an instance where a county or defending attorney is not in compliance with the current indigent defense standards. This finding is not necessarily a Public Defense Commission determination of a deficiency as defined in Idaho Code, because the Commission would still require a finding of material and willful non-compliance before any of the takeover or enforcement provisions of the statute would be invoked. Fiscal year, I point this out simply because the state and the county have different fiscal years, but when we talk about fiscal years in regards to our rules, we're actually going to talk about the county fiscal year, unless otherwise stated. And so we define fiscal year in here as beginning on October 1st and ending on September 30th of the following calendar year. Oversight review. This is also a new definition. 610106 will be the rule in which we'll talk about this a lot. But this is an annual or periodic review of a county or defending attorney completed by Public Defense Commission staff, most likely the regional coordinators, that considers whether indigent defense standards are being met and if deficiencies are being identified and cured in a timely fashion. Public defense roster. This is not a new definition, though it has been slightly altered from previous. The roster of defending attorneys who may be appointed to represent indigent defendants or other persons entitled to be represented by an attorney at public expense. The change would include the word compliant in front of defending attorneys, and so the definition would say a roster of compliant defending attorneys. So attorneys that are on the roster will have been deemed to be compliant with current standards. The last definition that I will talk about is workload. And I had brought up caseload, and I'm mentioning workload just to show the differences between the two. Workload recognizes that a caseload generally consists of a mix of case types that each require differing amounts of time and resources. So this would talk about how much time the attorney is spending on cases versus how many cases the attorney actually has. All right. Now we'll talk about 610106. This is a new chapter. It is, as mentioned, going to be published in tomorrow's legislative bulletin. The version that you should be able to pull up on your computer is the same version that will be published tomorrow. The authority for this chapter is in 19850, subsection 1, little 6, but also subsection. Oh, and I apologize. There is an error here in my citation. It's subsection 1A, little vi. Apologize for that. All right. So I'm going to briefly go through this rule. And if you're looking at it, I'm going to go ahead and skip to the second page, to section 20. The first page are standard things that are in our rules that talks about our legal authority to create the rule, administrative appeals, all those things will be in every chapter. Section 020 is the oversight program. This talks about how the Public Defense Commission shall oversee compliance with indigent defense standards. The PDC staff shall act as advisors to the PDC to oversee and monitor the public defense delivery systems provided by the counties to assure compliance with standards. In this chapter, we talk about the participants and the roles. I will talk about that in more depth here on another slide. There's a section called Minimum Standards, section 022. This just says that the minimum standards for review are contained in IDAPA 610101 through 610108 in all documents incorporated by reference. So all our rule chapters and any documents incorporated by reference are the minimum standards that must be met. I'll talk about the oversight program management section of the rule. I'll also talk about the procedures for the oversight program, talk about the corrective action plans. Just a moment. There we go. I'll talk about the corrective action plans and the compliance verification, and then I'll talk about the enforcement. The participants and roles. So the Public Defense Commission are a participant in this process, the commission itself, and then also the staff. In the rule, they talk about the responsibility of the commission, and we talk about the responsibilities of the staff. I think it's really important to note here that the commission is the one that assesses compliance ultimately. They are the ones that make the decision whether or not to engage in any enforcement. They will be the final determiners of compliance. The staff is essentially to help the commission make their decisions. So they're out on the ground. The regional coordinators are out in your counties and your regions. They're talking to you. They're meeting with you and your counties, and they will provide reports to the commission for the commission to make decisions. But they'll review defending attorneys and counties for compliance, identify and investigate reports of noncompliance, prepare and assist in the implementation of corrective action plans, report to the commission with respect to oversight activities and what kinds of things are they doing for oversight. They're going to review and assist with indigent defense grant applications. They'll review and assist with end reports that attorneys create. Basically going to be a resource for anybody in their region to help with anything related to public defense. Indigent defense providers and defending attorneys are participants. This rule establishes that they should participate meaningfully in the PDC review process, and so, and this is based on the statutory authority given to the Commission in 19862A1. Attorneys are to report any deficiencies with compliance as soon as reasonably practicable. They should report to the Commission any barriers that they have to compliance, despite their efforts to comply. One such example might be initial appearances. In some counties, magistrate judges are are hosting or holding initial appearances at times and not waiting for an attorney to show up. And so even though the attorney is making their efforts to show up at an initial appearance, they can't get there because the magistrate judge already held it. And so that would be a barrier that we would like to know about so that we can work with the appropriate parties to assist in making compliance possible. And we're also asking attorneys to assist PDC staff with the collection of records, documents, and any data that's related to the provision of indigent defense. The other participant is counties, and we do define here who we would like to see participating in our process. And in the rule it says counties through each board of county commissioners and other county staff necessary for the administration of indigent defense services are subject to our program. This is actually a narrower definition than our statute. So the statute, Idaho Code 19-862A, subsection 1, says that counties must cooperate. We're trying to limit what that means. Somebody that has nothing to do with indigent defense should not be subject to our rules. But counties are being asked to anticipate review and be prepared to enable a reviewer to issue a report to the Public Defense Commission within 30 days once the review has taken place. Just as attorneys, we're asking counties to report to the Commission all deficiencies with compliance as soon as reasonably practicable, and also report to the Commission all barriers to compliance. And I would suggest the same example as I did before. If a judge or someone not subject to our standards is preventing compliance with standards, we would like to know about that. And I can assure you that if there is a barrier, that the Commission would not find that a county or an attorney is willfully not complying or materially not complying with standards. If there's a barrier, we just want to help you remove that barrier, but we wouldn't hold the barrier against you. Section 023, Oversight Program Management. The oversight program must determine if indigent defense standards are being met, determine if deficiencies are being identified in a timely manner, and determine if deficiencies are being cured in a timely manner. And so the purpose of this section of the rule is to ensure that those things are being done. The applicability of the oversight program, the Public Defense Commission shall monitor the provision of indigent services in Idaho. We have the duty and authority to monitor counties, defending attorneys, and then if there are other stakeholders that we can monitor as allowed by law, we will. Such monitoring will include, but is not limited to, a review of an indigent defense contract. Once we create a rule about contracts, that will be something that will be included. Compliance proposals, those are the plans for how counties will come into compliance with standards and what kind of cost analysis, what kind of grant funds are needed to meet that plan. We'll review indigent defense budgets, annual reports of defending attorneys, and observe court proceedings and other things to make sure that standards are being met. Ongoing coordination. The purpose of this section is to talk about how we're going to continually coordinate with counties and attorneys. So PDC staff will conduct meetings and correspond with counties and attorneys as needed as needed, and then they will conduct a formal status meeting with a county once a quarter, so every 3 months, and with defending attorneys once a year. And a formal status meeting is really just a meeting, but it's one of those things that's required. The ongoing coordination throughout the year is not necessarily required, but highly encouraged. If a defending attorney is an employee of an institutional public defender office, a formal status meeting with the chief public defender of that office does satisfy the formal status meeting requirement as to that defending attorney. And so it's not required that PDC staff meet with every single employee of an institutional office. as long as there's been a meeting with the chief public defender that will satisfy the once-a-year meeting with a defending attorney. PDC staff reporting to the Public Defense Commission as part of the program management. PDC staff must make regular reports to the PDC. We have two different types of reviews that are defined in this section. One is a periodic review and the other is an annual review. An annual review is a review that will be conducted in the late winter and early spring of each year by PDC staff. Before April 15th of each year, staff will provide a summary of oversight activities for the year, a summary of compliance successes, deficiencies, and issues, a review of the implementation of the prior year's compliance proposal, and any changes to the provision of indigent defense services during the immediately preceding compliance period. You know, did a county go from a contract system to an in-house system? Did a county comply with their compliance proposal, or did they do something different with their grant funds? The reason why the deadline is April 15th of each year has nothing to do with tax day, but compliance has to happen by March 31st of every year. This actually only gives our staff 2 weeks to prepare these reports, and then counties are to have their grant applications in by May 1st. And so there's another 2 weeks in there that counties can look at the annual review done by staff and sort of incorporate anything in these reviews into their grant applications. So it's going to be a time crunch. I'm encouraging my regional coordinators to get on the annual review meetings so that they're not preparing all of their reports in that 2 week span of time. Excuse me. A periodic review. So a periodic review is not something that happens at any given period of time in a year. Basically, if a regional coordinator or someone else from the PDC staff or a commission member is informed that there might be a compliance issue somewhere, the regional coordinator or a staff member will conduct a review. You know, it's like someone submitting a complaint to us, and we would follow up on that. And they'll go out and complete what we call a periodic review. They'll prepare a report for the commission. Included in that report will be the date that we became aware of the compliance issue, what the staff member did to review and follow up on that compliance issue, any steps that are taken to resolve the issue, if it was an issue, if there was a corrective action plan created, and what that plan is, and then include a date of the next review or a follow-up to ensure that that the compliance issue, if it's deemed an issue, is being fixed. There is also a section under periodic reviews that talks about an initial review. This just asks Public Defense Commission staff to create an initial review of an indigent defense delivery system to make sure that they are in compliance. Or if a county, for instance, changes from a contract system to an in-house system, there would be an initial review of that in-house system to make sure that that office was in compliance with standards at the time. Ongoing consultation with the PDC. PDC staff will monthly report to the PDC to make sure that the Commission is aware of things going on around the state. They shall also notify the Commission within 10 business days of any compliance issues that affect the provision of indigent defense services. That way the Commission is always up to date on any compliance issues. And the rest of the program management talks about the Public Defense Commission reporting to these entities below, and then those entities reporting to the Public Defense Commission. So each year, the Public Defense Commission reports to both the executive and legislative branches by means of an annual report. We'll also report to counties. We'll give ongoing feedback to the counties through staff regarding any information that's been collected during reviews, any compliance issues or concerns, anything that has been raised to us that is relevant to the provision of indigent defense services. And then all reports that are created by PDC staff and submitted as a result of a review will also be issued to either the county or the defending attorney. We'll never do any of this in secret. All of this stuff will be open to your review. We ask in the rule that attorneys and counties and other stakeholders report to the Public Defense Commission on any observed compliance issues, any observed deficiencies that relate to indigent defense standards, so that we can be aware of things that need to be fixed. Or if it's not even an issue, we can at least say, hey, that's not really an issue, or it's not something that we can regulate. Procedures for the oversight program. This section just talks about how the oversight program works. Time and place, PDC staff will work with the party to identify a convenient period of time for on-site oversight activities. Notification, PDC staff will notify the subject of a review at least 30 days before the review is to take place. Extension, PDC staff may grant an extension for the conduct of a review, provided the PDC is notified by the party being reviewed within 15 days of the original notification date. Items subject to review, PDC staff will request and review the most recent compliance proposals, indigent defense grant applications, indigent defense contracts, budgets, annual reports, and other items relevant to the provision of indigent defense and compliance with standards. Items subject to observation. PDC staff will conduct field observation of courtroom activities and facilities available to and used by indigent defense providers, defending attorneys, and their staff in the course of the representation of indigent defendants. Persons subject to interview. PDC staff will interview county officials, indigent defense providers, defending attorneys, and other stakeholders who are involved in the administration of indigent defense services. And then the timing of a report. PDC staff will issue a report within 30 days of completion of the oversight review or by April 15th of each year if it's an annual review. Corrective actions and compliance verification. These are forms to address how indigent defense standards are to be met and how any deficiencies will be cured. Corrective action plans. As I mentioned, if there's a report of noncompliance by staff or the commission, a county or defending attorney, whoever is the subject of the noncompliance, shall describe a proposed corrective action to be taken. This corrective action will be something that can be worked out with staff. You're not on your own to figure it out. But the plan should be submitted to the commission electronically, which I usually mean by email, which is fine, using a reporting system that we specify, and that'll probably be through email. Facsimile will probably be okay as well. County and attorneys are asked to respond within 60 days of a report issued by staff that mentions a finding of noncompliance, and so we ask that within 60 days, if a staff member says, hey, you're not compliant, you have 60 days to respond with a corrective action plan. There is a portion of this section that says you can ask for an extension of another 60 days if you don't have enough time to create your corrective action plan. So effectively, you could have 120 days to create that corrective action plan. Follow-up reviews. PDC staff shall conduct follow-up reviews when a corrective action plan is put in place to make sure that the corrective action plan is being followed. And then if the implementation of a corrective action plan would take longer than 365 days, then the staff shall provide a formal yearly report to the commission of that corrective action. And then compliance verification is a form that counties will fill out if they choose not to file for an indigent defense grant. That way the commission can determine whether or not a county is in compliance per IDAPA 610104 and under our statutes. And the fun part, enforcement. This is the last section of this rule that I'll talk about. But I want to kind of describe how the Commission sort of sees the enforcement. Currently, under Section 19862A, subsection 1, all counties and attorneys shall cooperate and participate with PDC. Under that same statute, there are two mechanisms by which the Commission can enforce compliance with standards. The first one would be by withholding an indigent defense grant. The second one would be if the Commission finds that a county has materially and willfully failed to comply, then the Commission can go into the county, fix the problem, and then bill the county for it. And then there's this provision where if the county doesn't pay, then the state can withhold some of their tax revenues. It seems pretty drastic for that to be the first step for enforcement. And so because we were given the authority and the duty to create a rule regarding enforcement, we took the opportunity to sort of create a more incremental response. So basically, we want to do a few things before we start withholding grant money or we go in and take over. So the intent behind this chapter and the language in this rule is to provide that incremental response. So the first thing would be the failure to submit to review. So if a county or an attorney just fails to cooperate in a review, the first step that would be taken is that the PDC executive director, who is currently myself, would go in and do the reviews. Continued failure to submit to review would result in a certified letter designating a deficiency. So then the Public Defense Commission would say, okay, you're deficient, and then we could, under Section 19862A, follow up and go in and force the review, basically. Failure to respond to a report. So if a county or a defending attorney fails to respond to a report, so when we talked about the corrective action plans, if a PDC staff says, hey, here's a letter, you're deficient, and you're supposed to come up with a corrective action plan. So this is what happens if there's a failure to respond. Then a certified letter would be sent to the subject of the report designating a deficiency. And then such deficiency would be deemed a finding of noncompliance, and the PDC could take action under the statute. County noncompliance. If a county fails to take steps to correct a finding of noncompliance, the PDC could take action under the statute as allowed by law. Defending attorney noncompliance. If a defending attorney fails to take steps to correct a finding of noncompliance, the following actions will be taken. The county or counties for which the defending attorney provides indigent defense services will be notified via certified letter as to the noncompliance. The defending attorney will be removed from the public defense roster. The defending attorney may reapply for inclusion on the public defense roster after the finding of noncompliance is corrected. The defending attorney may still provide indigent defense services during this time. So the effect of being removed from the roster would simply mean that the attorney could not take advantage of training programs offered by the PDC, could not take advantage of scholarships offered by the PDC or any of our other resources. If the defending attorney continues to be deemed noncompliant after a period of 6 months, the defending attorney will be prohibited from accepting any additional indigent defense cases in any county in which said attorney has been deemed noncompliant. Such prohibition shall remain in place until the PDC makes a finding that the defending attorney is compliant. So our hope is that we could take incremental steps before having to reach any sort of takeover or having any defending attorney not be able to provide services anymore. Our intent is that regional coordinators would be out in the field really assisting with compliance and how to be compliant, and how you can make use of the Public Defense Commission resources to be compliant, so that we wouldn't ever have to resort to such drastic measures. Designation of a deficiency. So I mentioned this sort of as I was describing what happens when you fail to submit to a review or fail to respond to a report. So what is a designation of a deficiency? The designation of a deficiency is a formal designation made by the PDC indicating a county or defending attorney's unwillingness to comply with these rules as required. The PDC will maintain a list of designated deficiencies that will be made available upon request. When a deficiency exists for a period of more than 6 months, or, persists through the indigent defense grant application process without a compliance proposal that sufficiently addresses such deficiency, the party responsible for the deficiency will be determined to have willfully and materially failed to comply, and the PDC will take action under Section 19-862A Idaho Code, which is the section where the PDC can come in and take over and fix the deficiency. And then the last section under enforcement is the final determination of noncompliance. This paragraph, the intent behind this paragraph is to say that the commission is the one that makes the determination of noncompliance. Regional coordinators, my deputy director, myself, we as staff are not the final determiners of noncompliance. So if a regional coordinator comes in and says you're not compliant, you can take that for what it's worth. That ultimately, until the Public Defense Commission itself, so the 7 members of our commission make the determination, it's not an actual finding of noncompliance for which action could be taken under the statute. And so when you read this paragraph, which I'll read to you, if that's not what it says, then we need to amend it. But that's the intent behind the paragraph. It says the PDC is ultimately responsible for the determination that a county or defending attorney has willfully and materially failed to comply with standards. Pursuant to 19-862A, the PDC may, upon review of PDC staff reports, stakeholder reports, grant applications, compliance verification reports, or other information that it has received, deem that a county or defending has willfully and materially failed to comply. And upon such a determination by the commission could then take action under Section 1962A. So as we end on that high note, enforcement is definitely not my favorite part of talking about these rules. It is something that we have been told that we have to create, and so that's what we're doing. And of course, if there is no review or oversight or enforcement, then the rules that we do create, the standards that we create, are then meaningless. But we do hope to see you at our public hearings that are coming up. You should see those on your screen now, and take comment on the things that you learned about our rules today. The intent of the oversight, it sounds like it could be burdensome. It sounds like it could be something that is going to take up a lot of your time. That's definitely not our intent. What we really want to do with this rule is to show you this is how we envision the oversight going, and we want our regional coordinators out there doing it for you, being the resource for you, helping you gather things, and helping you make it more efficient so that we're not interfering with your daily duties as defending attorneys or as county officials, whatever the case may be. And so we always encourage comments and feedback through our hearings, but also through email, or you may call us anytime so that we can help you, be a resource for you. A reminder about tomorrow's webinar. We'll send out the instructions for the link for the webinar in the morning. Hopefully you all receive that without too many problems today. I always suggest checking your junk email if you didn't receive the link, although if you're on here today, then you obviously received the link. But that will be at 11:30 tomorrow morning. And we'll go through 610107. We'll go through the current rule and then what we have proposed. Let me just mention that in 610108, which we talked about today, we will incorporate the standards for defending attorneys into that chapter, but I am going to talk about the proposed standards tomorrow in that webinar. And so we didn't go over those in detail today. The public hearings are all at 6 p.m. local time in the cities except for Boise. October 11th, next Wednesday, we will have our commission meeting at 2 p.m. and then the public hearing will start at 4 p.m. and this will be at the Grove in the River Fork room. The remaining meetings there, Caldwell, Idaho Falls, Lewiston, Pocatello, Coeur d'Alene, and Twin Falls are all at 6 p.m. in the local time for those cities. I really appreciate your participation today. It's always strange just talking to my computer and not hearing anything back, but I wanted to make sure I got through everything today. I'm going to go ahead and stop the recording. However, I am going to hang out. We do have a few minutes left, and so if you'd like to ask me some questions through the Q&A icon at the top of your screen, you may do that. But I'm stopping the recording.